Welcome back to Superior Sunrise. Now joining me are two very special guests to talk about an important subject. And going off of that, we have Russ Cordova, President of the Livestock Marketing Association of Texas, along with Tim Dohlen, immediate past President of LMAT. Both Russ and Tim have been involved in studying the implications of legislation currently pending in Washington, specifically H.R. 4058, a bill titled the Sale Act of 2017. So I'm going to let them take it away to further discuss the issue.
Thanks, Kirby. Yes, we've spent a lot of time studying the intended and unintended consequences of this bill. In fact, over the last few months, we've reached out to other state marketing associations, industry partners, to make them aware of the implications of H.R. 4058. Many of them were not even aware that this bill had been filed, much less the impact of it. However, when they were alerted, they agreed that the impact would be very negative on the livestock marketing system as we know it today. And the impact would be on all of us, producers, dealers, and livestock markets. Tim, as you know, the officers of LMAT have pledged to work for the best interest of the entire livestock marketing industry of Texas.
That's right, Russ. That's why we're here today to present what we found about H.R. 4058. To begin with, the bill says that the purpose is, and I quote, to establish a trust for the benefit of all unpaid cash sellers of livestock. Can't argue with that, can you?
No, sir. In fact, no one would argue that livestock markets should be protected from dealer default or any buyer default for that matter. But we do not believe that H.R. 4058 is the right answer.
That's right, Russ. We've studied this bill in detail, looking into the likely effects. We've also hired a well-respected attorney familiar with livestock issues and the Eastern default to review the bill. As a result, we found a number of unintended consequences and problems that would negatively affect the way we do business. Unfortunately, the bill's primary supporter, the Livestock Marketing Association, which is headquartered in Kansas City, Missouri, refuses to acknowledge these problems or address them in any meaningful way. Therefore, the LMAT board, along with a number of organizations in Texas and around the country, are opposed to H.R. 4058 because we believe that it will cause more problems than it will solve.
Okay, what exactly are problems with H.R. 4058? Number one, if this bill becomes law, clear title will be unclear. Fact, under this bill, all livestock purchased by dealers becomes subject to the dealer trust. What happens when the dealer sells cattle subject to the trust to a feedlot or producer that defaults? H.R. 4058 doesn't answer that question.
Number two, if the bill becomes law, there will be less bank financing. Fact is, this bill will reduce the value of inventory and receivables of dealers, which will reduce their ability to obtain bank financing. Dealers who lack the ability to pay for cattle are the problem in the first place. H.R. 4058 would increase that problem, not solve it.
Three, if this bill becomes law, markets will be forced to extend credit. Fact, 6 of the largest cattle buying entities in Texas have already signed a letter stating that they would not buy from a livestock market unless the market agrees to sell cattle on a credit basis, which gets everyone out of the dealer trust. Of course, we all know that selling livestock on terms increases both cost and risk.
And the fourth fact, if this bill becomes law, prompt payment will be irrelevant. Fact is, markets that allow dealers to operate on float will have less incentive to require prompt payment if they think they are protected by the dealer trust.
5, if this bill becomes law, every buyer could be a dealer. Fact, GIPSA's definition of dealer is very vague and can be broadly interpreted, making an opt-out or waiver provision unworkable. Attorneys representing both LMAT and LMA agree that there is no bright line test to determine who is a dealer. They also agree it is not limited to registered dealers. Therefore, it is impossible to know who will be subject to the dealer trust until a default occurs. And then lawyers and courts will step in to decide, costing everyone legal fees, and we all know what happens there. Nobody wins.
6, if this bill becomes law, there will be more lawsuits. Fact, in addition to the dealer issue, there is nothing to explain how this change to the P&S Act will solve the bankruptcy issue or prevent bankruptcies in the first place. It will take years of litigation before all the issues are resolved. Litigation that will cost markets, dealers, and producers money.
7, if this bill becomes law, producers may actually avoid markets and sell directly to dealers. Fact, it appears that no producer who sold through livestock market lost money from the eastern default. That is a good reason to promote livestock marketing.
Okay, so with all of these unanswered questions, why is there such a rush to pass this bill? What we need to do is get everyone together as an industry, producers, dealers, and markets to figure out the best way to protect everyone. A system that is good for all, not just one segment. What we don't need is a big rush to pass a bad bill that only increases governmental control.
That's right. This is all our industry and all of our livelihoods. We don't need more government interference telling us how to run our business. If you agree that the last thing that you need is more government interference in your business, please contact your congressman or U.S. senators. Ask them to just say no
To the needless government regulation and no to H.R. 4058.
Well, I want to thank Tim and Russ for both being on to talk about this issue. I know they were educating me a little bit more on it earlier yesterday, and we'll continue to discuss it. So I want to thank you both for being on here today to kind of share with our viewers everything that's going on. When we come back, a very special guest. Stay with us.